faced a judge as his long criminal history was laid out one by one, exposing years of serious convictions. In the end, a plea deal capped his sentence at 8 years, but the courtroom tension was far from over.
Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
The way he's talking it's going to be a lot bit worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the.
Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay? I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
And so, go
I'm
ahead.
sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading, so we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute. Thank you.
Sure.
Formal reading of the motion.
You would.
Mr. Dinkin, in cause number 19-32080, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 12th of 2019 for aggravated assault, and that was a 5-year deferred probation. Is that correct?
Yes, sir.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation office for the months of September and October of 2023. And is that true or not true?
Yes, sir.
True or not true? Thank you. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you tested positive for alcohol June 19th, July 12th, and August 28th of 2023. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered. Is that true or not true?
True.
Count 4 alleges that you are behind in your court assessed fees. Is that true or not true? And then count 5 alleges that you failed to complete the drug rehabilitation orientation program or the DROP program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Did you plead true, but did anybody force you to plead true to those counts? Okay. Did you plead true because
True.
they're actually true?
True.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 10 years in prison. And so as long as I give you 10 years or less, you understand that you're waiving any right to appeal, correct? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Dinkin is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing, get the probation department to do an updated report, and then. Okay, let's see. This is that April Smith coming. Oh, there it is. Just popped up as soon as I said it, of course. Good morning. Are you April Smith?
It's,
And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
it is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today to detectives to ask them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am, or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19, 33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true?
True.
Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
No,
case.
it's just fine.
Okay, so there is an agreement, actually.
There is actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
I asked them to file them and they still haven't.
Okay.
Yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted any evidence that Ms. Smith is not competent.
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for. And so Ms. Julian was previously in court and entered a plea of guilty to burglary of a building, which is a state jail felony that was enhanced, and the agreement was for a 10-year term in prison, probated for 10 years with restitution to be determined. There were some issues. Looks like I reset.
It was positive last time.
Right. And so I raised the bond, reset it for a couple of weeks, got a substance abuse assessment done in the meantime. Did everybody get a copy of that substance abuse assessment?
Did you?
Okay. Did you not?
I didn't, but I defer to the court on that.
Okay. Yeah,
I'm saying you didn't, I just,
It's okay.
sometimes they slip through. Sorry.
that's okay. So y'all have all been able to review the pre-sentence report, correct?
Yes.
Is there any reason not to go forward with sentencing at this time?
No, fast change.
Judge, obviously the state is aware of the court's concern about her criminal history, just so that you know, the co-defendant was sentenced to significant prison time in this case. I believe he was actually the one more culpable based on the facts. I've also reached out to the managers of the storage facilities in an attempt to gather a restitution amount. Obviously, her offer was made with the enhancement in an attempt to reclaim or regain that restitution. They were unable to provide me with that. I also reached out to the detective with respect to their attempts to contact all the individual owners, and I didn't receive a word back from that. It's my thought that probably they recouped those losses off their personal property insurance.
Okay. Okay. So do you have any input as to the recommendation under that substance abuse assessment is for either SafeP or ISF followed by JCDI? Any input, Mr. Lewis or Ms. Malfino?
What Judge, in talking with my client, she's more than willing to comply with whatever help that the community supervision department can give to her, especially when dealing with the mental health issues, which I think that's what kind of leads to a lot of the substance use problems that she's had. And she's straightforward and honest with them during the evaluation. So, Judge, I mean, whatever the court deems appropriate, she's more than willing to comply.
I don't know that what I'm looking for is to see if it states in here if special needs SafeP would be appropriate. I don't know based on the diagnosis of depression and anxiety, if that is enough for that with. How does that determine? Do you know?
She would already have to be diagnosed in order to do the special.
I mean, there's a diagnosis, it looks like. Well, I say that. Have you actually been to,
No, ma'am.
you have not been actually diagnosed. That's just how you feel.
Yes, ma'am.
Okay,
I mean, I was diagnosed when I was a kid, but.
right, but you haven't anything recently.
Yes.
Okay,
No,
so, all right, anything else then?
no.
No.
All right, Miss Julian, what I'm going to do, at this time, I'm going to find that you previously entered your plea of guilty and true freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty, and at this time, find you guilty of burglary of a building
Yes, ma'am.
and find those prior convictions true.
Yes, ma'am.
Sentence you in accordance with your agreement to a term of 10 years in prison, but that's going to be probated. You'll be on probation for 10 years. Because there was no restitution amount that was turned in, I am going to order that you pay a fine of $500
Yes, ma'am.
and that you follow all of the rules and conditions of probation.
Yes, ma'am.
One of those is going to be that you enter and successfully complete the substance abuse track of the ISF program.
Yes, ma'am.
And then when you're released from there, you will go through the outpatient JCDI program as your aftercare. I'm also going to ask probation when you are released to do a mental health evaluation. And if there's anything that you need, if you need to be on a specialized caseload at that point, they will put you on that to help you with any other issues that you're having. And so if you do everything that you're supposed to when you're on this probation, this is a great opportunity because for all practical purposes, your case here in court is over.
Right.
The other side of that, though, is if you violate any condition of probation and you test positive, you don't show up
Right.
for whatever it is, then you
No
will be
exception.
back in here and you'll be looking at that 10-year sentence that you've already agreed to.
Yes, ma'am.
All right. I'm going to hand you the trial court certification that shows this was an agreement that I followed. And so you waived your right to appeal.
Yes, ma'am.
I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Oh, I don't think they did it.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. I've got to read this to you.
Okay.
Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. And I will sign a dismissal as soon as it comes through as part of that agreement.